I know. Well, welcome all to one more session from Juris North, our monthly discussions. Today we have the pleasure, a colleague from China, Dr. Jing Zhao, a lecturer from the College of Humanities and Law, Beijing, and she will talk about the justification problem in Hans Kelsen's theory of legal validity. Before we start, first of all, thank you very much, Dr. Jing Zhao, for being here, and thanks to my friend as well, Dr. Wei Feng from Beijing as well. He will be our co-host today. Very basically, what we do at Juris North, we will have a keynote speaker, the expert, and the rest of us, we will play a game. It's simply, we are here to learn from each other. We don't have professors or students. It's, we are able to ask any question we want to Dr. Jing Zhao. And the very first part of the presentation will be recorded for the viewers. The rest of the discussion, questions and answers that will follow will not be recorded. Without anything else from me to say, I don't know if Wei, do you want to say anything before I introduce again Dr. Jing Zhao?
Yeah, I should very briefly, I should introduce Jing Zhao. Actually, she have done his PhD degree in Germany, that is Frankfurt am Main, and he spent almost 10 years there. And his major is on New Kantianism, especially Radpool, as well as Hans Kelsen. Yeah, that is my introduction for Jing Zhao. Yeah.
Perfect. Thank you very much for that. And Dr. Jing Zhao, without anything else from me to say, again, we'll hear your presentation about the justification problem in Hans Kelsen's theory of legal validity. Thank you very much, and the floor is yours.
Okay, now I will share my screen.
Perfect. Yeah, thank you.
Hello, everyone, and hello, Jörg. Thanks for inviting me. Before I begin my presentation, I want to and thanks Wei for the introduction. Since my academic language is first of all German, so I'm sorry for my limited English skills. And I'm very glad to have this opportunity to share my considerations about Kelsen's legal theory. And the main subject of my presentation is about the justification problem in Kelsen's theory of legal validity. Before entering the specific discussion of this problem, I want to clarify a point related to the about Kelsen's theory. The fact that Kelsen has abandoned his central position after his Salzburg presentation, namely the Grundlagen der Naturrechtslehre, is indisputable. However, there is still no common agreement about the phases of the development in his legal theory. One example is the discussions between Carsten Heidemann and Sterling Paulson, and how to interpret the changes within Kelsen's entire theory is not the subject of my presentation. And I would like to limit my research in Kelsen's classical Kantian phase, that is between 1920 and 1960. So that the basic norm is the result of juristic thinking and functions as a transcendental concept of legal cognition. And Kelsen is known as both a positivist and a normativist. This mixed position also influences his theory of legal validity. Regarding the assertion of separation thesis of law and morality, Kelsen stands on the side of the positivists who reject a metaphysical transcendent theory of legal validity. This position makes his theory as positivistic. At the same time, Kelsen opposes all of the naturalistic and empirical sociological theories of legal validity by emphasizing the dichotomy between is and ought, and between the descriptive and normative presuppositions, and connects himself with the critical tradition of Kantianism. This position makes his legal theory as normativistic. As the fundament of legal validity, the basic norm is a crucial point, but also the most criticized concept in Kelsen's entire theory. The central propositions of my presentations are follows. Firstly, I propose that when discussing the issue of legal validity, two different kinds of validity should be clearly distinguished, namely the epistemological one and the practical one. And they can be expressed in the following two questions. Question E, why is the law valid? And question B, why is the law binding, or why should I obey the law? And Kelsen's concept of legal validity refers to the above two senses at the same time. Secondly, Kelsen tries to use the model of the basic norm as a basis for the ultimate justification of these two different concepts of legal validity. Therefore, his concept of the basic norm is a hybrid or a mixture. This presentation attempts to analyze and criticize why the basic norm is not able to provide the ultimate foundation for the legal validity in these two senses at the same time. And thirdly, if Kelsen would also like to justify the practical validity, it is not sufficient to merely inherit the theoretical part of Kant's philosophy, especially Kant's a priori methodology, because legal obligation is not a concept in an epistemological sense, but can only be justified through the unity of wills. Therefore, my presentation is divided into three parts. The first part discusses the two different concepts of Kelsen's legal validity and his justifications of these concepts. Question A, why is the law valid? This question refers to the legal validity in a theoretical sense, namely as the modus of the existence of legal norms. The specific existence of legal norm consists in its validity. For example, if a person A deliberately murdered, he should be sentenced to a liberty penalty according to the German criminal law. When we see that a legal norm exists, we mean that this norm is valid. Thus, legal norm always coincides with his validity. In this sense, Kelsen transferred the why question relating to the legal validity, namely why is the law valid, into a how question. How can the positive law be understood as legal norms? How is positive law qua object of cognitive legal science possible? As long as the law should be interpreted as norms, the issue of its validity could be solved. In this process, legal norms function as the scheme of interpretation. Through the category of imputation, the legal norms confer a juristic meaning upon the positive law. Then, the positive law is constituted as valid legal norms. Kelsen operates his question under an epistemological view. In this point, Kelsen traced back to Kant's first critique and offers an answer with his well-known doctrine of the basic norm, which functions as the transcendental logical condition for the possibility of a normative interpretation of the legal materials. On this basis, the normative dimension of the law, its validity in the sense of its logical possibility as norms, can be explained. Since the nature of legal norms are only obtained through the analysis of semantic structure of juristic statements, the basic norm is merely a presupposition of the juristic thinking. As Kelsen writes, that the basic norm really exists in the juristic consciousness is the result of simple analysis of actual juristic statements. The basic norm is a hypothetical condition of all legal cognition which can be, but not must be, presupposed. It has no fixed size, and this presupposition is not necessary. Paulson also points out that the basic norm is only a possible justification of the legal validity, but not a necessary one. And these critics are convincing. There is a condition for the necessity of the basic norm. Its presupposition as a transcendental category is only then necessary if one, especially the legal scholars, want to or will understand the positive law as an objective, valid normative order. Matthias Yerstedt describes it also as, instead of categorical validity, only hypothetical validity, instead of bread, just a stone. And then we go to the question B, why should the law be obeyed? Referring to this question, the concept of legal validity is used in a practical sense, namely as the binding force of the norm. The norms are legally binding for those whose behavior they regulate. The legal validity means not only that the law is valid, but also that the law should be obeyed. In the article, The Pure Theory of Law and Analytical Jurisprudence from the year 1941, the validity of norms is directed towards the human behavior. Norms are valid for those whose conduct they regulate. In two other papers, from the 1950s, Kelsen also understands the validity of law in the sense of its binding force. And in his fundamental work, Pure Theory of Law, the second edition from 1960, Kelsen continued this understanding and said that a norm is valid means that it is binding and that an individual ought to behave in the manner determined by the norm. And also in his posthumous book, General Theory of Norms, this statement is maintained. As he writes, that a norm is valid means that it ought to be followed and applied. But in which way did Kelsen fulfill this mission of justifying the practical legal validity? On the one hand, Kelsen warns that the question of how people should behave according to a positive legal order should not be confused with the question of how they actually behave. The latter one is determined by choral laws. Thus, Kelsen opposes a syncretism of a norm scientific with a choral scientific determination of the legal validity. The reasons for the validity of law cannot be facts. As he writes, the mere fact that somebody commands something is no reason to regard the command as a valid norm, the norm binding the individual at whom it is directed. As odd norms, the law can neither be true or false, but can only be defined as valid or invalid. The search for the reason of the validity of norms is, according to Kelsen, different than the search for the cause of an effect. He is in this sense against Huagong Ehrlich, who speaks choral sociology and attempts to refer the reason of the legal validity to social facts. On the other hand, the binding force should not be caused by a moral obligation, the justification of the legal validity through any moral philosophy or natural law approach is rejected. Legal norm is a kind of moral free and pure formal ought. The pure theory of law only concentrates on the logical structure of legal norms and not the substantial standards for the correctness of their contents. The content of legal norms can be completely arbitrary. The starting point of Kelsen's project is the methodological principle of the new Kantianism. The validity of the old norms comes only from those norms which have the same nature. Consequently, the validity of legal norms must end with a norm which at the last and highest is presupposed. The highest presupposed norm is the basic norm. This norm does not aim to provide content for legal norms, but only to provide the reason for their validity, and not only for the theoretical, but also for the practical legal validity. And there are some passages from Kelsen's work, and they can be the proof for the statement that the basic norm by Kelsen also gives the binding force to the law. The answer to the question, why should the orders of the prince, the laws of state, be obeyed? Why are they norms? In short, that one to which the validity of the specific legal order can be traced back, can in turn only be an ought, the supreme, not further derived norm. You should obey the orders of the prince or the laws of the state. And another passage, the basic or original norm, which establishes the system of legal order as its typical content, that an authority, a legal source is used, the statements of which are to be considered legally binding, behave like the legal authority, the monarch, the People's Assembly, the Parliament, and so on, commands. This is the basic norm, simplified for the sake of clarity. In the second edition of the Pure Theory of Law, Kelsen uses many examples to illustrate the validity of legal norms, such as the child should obey the order of his father to go to school. God commanded the child to obey his father, and God's commands should be obeyed. A man who takes a girl as his wife should pay the girl's father or uncle a certain bride price. The central ideas of these examples are the reason to obey these norms. For Kelsen, the norm forming the starting point of the question does not apply by virtue of his content. It cannot be deduced from the presupposed, the basic norm, by logical operation. And the second part discusses the problem in Kelsen's justification of the legal validity in a practical sense. The question now is it possible to justify the binding force of law through a merely epistemologically presupposed concept? How can the basic norm, which itself is presupposed valid, be the reason for the legal obligation? The statement of the basic norm is one ought to obey commands of the creator of the Constitution, or one ought to behave as the Constitution prescribes. This statement of the basic norm and its validity is only a presupposition, but not a prescription. Kelsen also writes that the Constitution is valid and binding. It means that one should behave as the Constitution prescribes. Although in both cases, Kelsen seems to talk about the same subject, the legal obligation that one ought to obey the Constitution, but the legal obligation in the second case belongs to a practical category and cannot be justified by a merely presupposed concept as a form of thinking or a cognitive construction, namely the basic norm. With this concept, the appellative function of law cannot be justified or only appears to be justified. Next, I will talk about the relationship between legal norms and human behavior. The legal norm plays two roles. Firstly, it confers a juristic meaning upon the time-space positive law, and second, it is binding and ought to be obeyed. The legal norm in the first sense refers to the subjective meaning of the act of will, which can be interpreted as objective meaning. The act of will belongs to the realm of is, while its meaning belongs to the category of ought. In this way, the subjective ought of the command is legitimized. Through interpreting the subjective ought into an objective one, the positive law obtains a normative character. The legal norm in this sense can be formulated as that the law is valid. In the second sense, the content of the legal norm comes into consideration, which refers to the act. For what the law is valid. What the norms of an order regulates is always human behavior. In this case, Kelsen talks about the legal validity in the sense of binding force. The ought is directed towards an is, the norm to an actual human behavior. However, what does human behavior mean according to Kelsen? For answering this question, there is a key concept, namely das Gesollte-Verhalten, so of English, the behavior that ought to be. Kelsen distinguishes between the behavior which is stipulated by a norm as a behavior that ought to be and an actual behavior that corresponds to it. But the legal scientist equals the later one to the former one. Therefore, the behavior that ought to be is ambiguous. First, the behavior that is the content of the norm, and second, the actual behavior. Thus, the pure theory of law only involves the virtual factual behavior, which not belongs to the models of is, but to the models of ought. The normalization of the human behavior through the legal norm cannot be understood in a practical sense. Thus, although Kelsen refers the binding quality to the legal norm, the validity of the legal norm cannot reach his intended addressee. The object of the binding force of law can only be the human behavior, not as a virtual being, but as a factual one. This cannot be touched by the pure theory of law as a theoretical legal science. The binding force belongs only to the practical category whose purpose is not to know his object, but to regulate it. In part 3, I want to show a possible way to solve the problem of both concepts of the legal validity through interpreting Kant's practical philosophy. Kant's project aims to establish an objective world, not only in nature, but also in the human world. Through the doctrine of law, Kant tries to transform the legal theory into a scientific and true knowledge of law. He poses the following question to himself: how is the legal action a priori possible? Under which condition can a human action be understood as a legal action? For Kant, the law can be defined as a whole of the conditions under which the free use of the choice of Deutsch Willkür of any one person can be harmonized in reality with the free use of the choice of every other person, according to a universal law of freedom. The universal principle of law is defined by Kant as follows. Every action is Recht, which in itself or in the maxim on which it proceeds is such that the free use of your choice can coexist with the freedom of everyone in accordance with a universal law. Every human behavior which externally obeys the law can be concerned as an agreement of actions with the law, that is, in conformity with duty. The universal principle functions as a condition of the possibility for the knowledge of the object of law, that is, legal action a priori. The possibility of legal actions and insofar the validity of law consists in a priori synthesis of law and human actions, and not the empirical principles. Through the postulate of this principle, the epistemological objectivity of law is ensured. Kant's legal doctrine refers only the possibility of the legal action. Under the condition of the universal principle of law, human action becomes a legal action, namely duty. But this principle only concerns the objective structure of actions, that is, whether and how an action conforms to the law of duty. Thus, through it, only the legality of human actions is justified. Duty, as far as the action is concerned, may be one and the same, and yet we may bound to it in various ways. The juristic legislation does not include any motive principle. The question of motive choice is a question of the reason for obligation. Now, we have already entered and must enter the moral practical territory, because only the practical reason does the justification of the practical validity as obligation reside. Through the question, why should I obey the law, or why should I do my duty, Kant connects the doctrine of law and his moral philosophy. Kant opts to find the reasons of binding force in human nature or experience conditions, but only in the obligation itself. The fulfillment of obligations lies only in observing the requirement of the categorical imperative, which is expressed in normative presuppositions grounded in laws of freedom. The practical reason as the reason for the binding quality of law, which claims or obedience, is characterized by concern with the determining ground of the will. Ought cannot be derived from any is, so that the ultimate and the true determining principle must be independent from all empirics and experiences, which convey the practical rules only a conditional university. For Kant, the doctrine of natural law is only a moral anthropology and an empirical science of the moral nature of man, whose statement has no difference to an authority power theory. Both the doctrine of natural law and positive legal theory only offer an empirical foundation for law. The basis of obligation must not be sought in the nature of man or in the circumstances in the world, but a priori simply in the conceptions of pure reason. The only motive which is allowed to be the reason for obligation, is the idea of duty itself. For Kant, the categorical imperative generally expresses what constitutes obligation. Act as if the maxim of your action were to become by your will a universal law of nature. Thus, I obey the law only for the sake of the moral law, so that my action is not only morally correct as a deed, but also in conformity with my maxim, morally worthy as an attitude. The command of moral law is categorical. It regards an action as being necessary in itself without reference to any other end. That is, as objectively necessary. Only those laws which bear an absolute necessity can be the basis of obligation. Therefore, Kant takes two steps to complete his program of justifying the law. As a first step, the possibility of law which only concerns the external human behavior is justified through a transcendental principle of law. Through this, Kant ensures the scientific character of legal doctrine and makes it a true knowledge of law. We know whether and how an action is a legal action through this principle of law, which makes our action a duty. As a second step, the moral law, which concerns itself with the determining ground of the will, makes the duty a reason, so that the legal obligation, why should we obey the law, is successfully justified. His systematic work of practical philosophy, Metaphysics of Morals from 1697, consists of two parts. The first part is the principle of law as the transcendental condition of legal actions and their knowledge, and the second part, the categorical imperative as the reason of obligation. Both principles integrate themselves in the principle of freedom. And now to sum up my conclusions, there are two categorically different questions. First, why the law is valid, and second, why is the law binding? Kelsen has successfully answered the first question through his concept of the basic norm, which functions as the transcendental logical condition of the possibility of legal norms. However, if we ask the reason for obedience to the legal norms, we are seeking a concept which can provide regulative meaning for us. The basic norm has only a constitutive meaning, so that the justification of the binding force, which refers to the human behavior, is actually irrelevant to it. The concept of obligation is not an epistemological concept, but can only be viewed under a practical perspective. Thus, Kelsen's attempt to provide any legitimacy for the binding quality of law with an epistemological concept must be broken down. He tries to structure the question of the practical philosophy by following Kant's model of the first critic, but renounces Kant's practical part of the categorical imperative. In Kant's theory, the subject will is legitimized through moral will, whereas Kelsen only legitimizes the subject meaning of the will to its objective meaning. The basic norm is no determining ground for the will itself, but merely whose theoretical meaning. In justifying the law, Kant connects his initial transcendental method, which he applies in the epistemology, with the practical category of the will. For the reason of obligation must finally be a matter of will. I obey the law because I recognize it ought to be obeyed. The justification of the binding force of law consists in a unity of wills. Thus, the legal rules are such a concept which necessarily includes the idea of an end in themselves. The highest unity consists not in the legal system as a whole, which means the unity of knowledge of law, but in the unity of establishing one end, the idea of freedom. In Kant's philosophy, the idea of freedom turns not only to be the basis for practical reason, but also the Schlussstein for the whole building of speculative reason. As long as Kelsen denies any kind of idea which is for him unscientific or makes his theory impure, then he should keep his theory modest to stay within the epistemological sphere and accept the truth that this kind of theory is incapable for providing any reason for the practical validity of law. It is not possible for an epistemologically basic norm to reach the final point of unity between legal rules and human actions, which can only consist in a unity of wills. Kelsen's idea of the basic norm is, according to Matthias Yerstedt, instead of being a keystone, the basic norm is now just an emergency nail. And thanks for your attention. And now you have the words.
Thank you very much, Dr. Jing Zhao, and I'm going to stop the recording now so to allow for questions and answers. Thank you very much. It's been a pleasure. Let me stop here the recording.